Imagine, imagine you have spent thousands of hours and like thousands of dollars earning your board certification in behavior analysis.
Right. Oh, yeah. It's a massive investment.
Exactly. And you are a master of the science. You can look at this complex behavioral data graph and just, boom, spot the function of a behavior instantly.
Right.
But then you forget to renew a single piece of state paperwork. And suddenly, just handing out your own business card is a fraudulent act.
It's terrifying.
It really is. Your entire career is on the line. Not because you don't know the psychology, but because you tripped over, well, the legal tape.
And that is a very real, terrifying reality for a lot of well-intentioned practitioners out there.
Yep.
Because it is incredibly easy to treat applied behavior analysis purely as a clinical science, you know? And we kind of forget that it operates inside this highly regulated, really high-stakes legal framework. I mean, if you don't understand the rules of the road, the science simply won't save you.
So true. Well, welcome to today's deep dive, everyone. We are taking a magnifying glass to domain E12 of the BCBA test content outline.
The big one.
The big one, yeah. The legal, regulatory, and practice requirements that dictate how behavior analysts actually survive in the real world.
Absolutely.
And we are pulling from a massive stack of sources today. We've got the official BCBA handbook, the 6th edition test content outline, mock exams, and some incredibly eye-opening real-world case scenarios from Bailey and Birch's ethics workbooks.
Which are just fantastic resources. And, you know, the goal here is to really translate what looks like this dense, intimidating textbook syllabus into, like, memorable survival skills.
Right, because this isn't just academic.
No, not at all. Ignorance of these frameworks doesn't just result in a slap on the wrist. It can lead to profound ethical harm to the vulnerable clients you're serving. And frankly, it can land you in serious legal trouble.
So let's start at the very foundation. Because before a practitioner can even think about observing a client or billing an insurance company, they have to legally prove who they are.
Which sounds simple, but
it's not. Our sources highlight this massive point of confusion in the field, falling under Code 1.02, which is conforming with legal and professional requirements.
Right.
And it really comes down to the difference between BACD certification and state licensure.
Yeah, this trips up so many people. So the Behavior Analyst Certification Board, the BACB, they issue your certification.
Mm-hmm.
That is a national and in many ways an international verification.
Right.
It proves you met the educational requirements, you did the field work, and you passed that massive exam.
Right. You are officially a board-certified behavior analyst.
Exactly. But, and this is the big but, that certification does not act as a skeleton key to practice anywhere you want.
Right.
Because many individual states have their own licensure boards, and they issue the title Licensed Behavior Analyst, or LBA, and they are the ones who dictate who can legally practice within their specific borders.
And the sources include this really specific case study from the ethics workbook. I think it's called Licensed to Ill.
Yes. Oh, that's a classic one.
It perfectly captures the psychology of how practitioners fall into this trap. So it features this guy named Andrew.
Right.
And Andrew is a highly competent BCBA practicing in a state that requires licensure. He's doing everything right with the national board, keeping up with his continuing debt, paying his BACB fees. His board certification is flawlessly valid.
And completely spotless.
Right. But he gets lazy with his mail and completely misses the deadline to renew his state license.
And the critical error, the really huge mistake, is what he does next.
Yeah.
Because he keeps handing out his old business cards that say BCBA, LBA. He just continues to operate as if literally nothing has changed.
Which is wild, but you can almost hear his internal monologue, right? He's probably thinking, well, I still know the science, I'm still board certified. My brain didn't suddenly forget how to analyze behavior just because I missed a state filing deadline. It's just a paperwork delay.
But the danger there is that the state licensure board and the BACB, for that matter, they do not view it as a mere paperwork delay.
No, they don't.
It is a massive ethical violation. It is misrepresentation. I mean, essentially, it is consumer fraud.
Wow, consumer fraud.
Yeah, because the moment that license expires, you no longer hold the title of LBA. You cannot advertise credentials you do not actively possess. Period.
I always think of it like passing your driver's ed test, getting the certificate of completion, but letting your actual driver's license expire.
Oh, that's a great way to put it.
Right. If you get pulled over, you can't just wave the driver's ed certificate at the police officer and say, but look, this piece of paper proves I know how to parallel park.
The officer does not care.
Exactly. The officer doesn't care. You aren't legally allowed behind the wheel in that state.
And The mechanism here is identical. You have to comply with both the overarching professional board and the local jurisdiction. And actually, incidentally, if you are sitting for the board exam and you see a question asking which set of rules a BCBA should follow, like the BACB code or state law.
Oh, good tip. What's the
Yeah.
answer?
The answer is always both. If they conflict, you have to adhere to the law while making your commitment to the ethics code known and, take steps to resolve the conflict.
Okay, so Andrew finally gets his act together, gets his state license renewed. He's legal.
Finally.
He walks into his first client's house, ready to do some good. But before he even collects a single baseline data point, he's about to step on another ethical landmine, which is the service agreement.
Yes. So CUND 3.04 dictates the rules for service agreements, and the timing is the absolute most critical element here.
Right, it has to be upfront.
Exactly. A signed agreement outlining the responsibilities of all parties, the exact scope of the behavioral services, and your obligations as the analyst that must be in place before any services begin. Before. You cannot start observing a child on Monday with the promise that the parents will sign the contract on Friday.
And the sources specify that this agreement must also include the procedure for how a client can file a complaint against you, which I found fascinating.
Yeah, it's pretty intense.
You literally have to hand them the roadmap for how to report you to the BACB or their insurance company if they feel you're violating the code.
Because transparency is non-negotiable. And honestly, that transparency becomes infinitely more complicated when we introduce third-party contracts under Code 3.07.
Oh yeah, third parties get messy.
Very. This rule exists for a very specific historical reason. So in the past, you might have a school district, the third party hire a BCBA to evaluate a disruptive student who is the first party.
Okay.
The school district might secretly, or not so secretly, be looking for a behavior plan that justifies placing the student in a cheaper, less intensive classroom setting.
Right.
Meanwhile, the BCBA's actual data shows the student desperately needs expensive one-on-one support.
Wow, so that puts the BCBA's paycheck in direct conflict with the student's actual needs.
Precisely. Which is why Code 3.07 mandates that the BCBA must clarify the nature of the relationship with everyone involved from day one. Who is the ultimate client? The student.
Always a student.
Who gets access to the data? Are there limits to confidentiality? If the school district pushes for an intervention that is not in the best interest of the student, the BCBA has a legal and ethical mandate to protect the student's welfare way above the demands of the entities signing the paychecks.
And speaking of paychecks, we have to talk about the billing examples in the Bailey and Birch source material.
Yeah.
Because they are staggering.
Oh, they're hard to read.
We are talking about blatant fraud that goes way beyond handing out the wrong business card.
Yeah, the texts highlight cases where supervisors were padding timesheets to increase agency income without actually providing the clinical hours.
It's awful.
And even worse, there are documented instances of RBT's registered behavior technicians reporting that their supervising BCBA assigned them to walk the BCBA's dog.
Walk their dog.
Or run down to the deli to pick up lunch for the office.
And then the BCBA billed that time to Medicaid or private insurance as RBT clinical therapy time.
Which is just mind-boggling. The psychology behind that usually stems from a supervisor abusing their power, thinking, well, the RBT is on the clock, I'm supervising them, who cares what specific task they're doing?
Right.
But billing a federal funding source for a deli run is defrauding the government. The BACB code mandates absolute accuracy in billing. Furthermore, the sources really hammer home that ignorance of funding regulations is never an excuse.
Okay, hold on. I have to stop you there.
Sure.
Because I completely get that having an RBT walk your dog is fraud. We all know that. But you're saying ignorance is no excuse for billing errors. Anyone who has ever looked at TRICARE, Medicaid, or private insurance billing codes knows they are a labyrinth.
Oh, absolutely. They're a nightmare.
And they change almost weekly. So how is a solo practitioner or just a brand new BCDA supposed to keep up without accidentally committing fraud?
That is probably one of the most valid anxieties for any practitioner. I mean, it's scary, but the reality is the board expects you to treat billing with the same rigorous, data-driven approach you use for clinical interventions. You cannot operate in a silo and just hope for the best. You have to actively build a compliance network.
So, reaching out for help.
Yes. If you are an independent practitioner, you need to consult with billing experts or legal counsel who specialize in behavioral health. If you work for a large clinic, you should be asking to see how your specific hours are being coded and billed to the funders.
That makes sense.
Taking the initiative to self-audit is part of your ethical duty. You just don't get a pass because the bureaucracy is complicated.
Right. It's an active pursuit of compliance, not a passive one. You have to own it.
Exactly.
So contracts and billing dictate the business of ABA, but the law dictates client safety. Let's transition from protecting the practitioner's license to protecting the physical safety of the highly vulnerable clients they serve.
Yes. This introduces confidentiality and mandated reporting.
Two huge topics.
Huge. Under Code 2.03, protecting confidential information, your default setting is ironclad silence. You do not disclose confidential client information without explicit, informed consent.
But there are exceptions, right?
Yes, the law provides very specific emergency override scenarios where a BCBA is legally obligated to break confidentiality, even if the client begs them not to.
And the sources outline three major exceptions. It's protecting the client from imminent harm, preventing a crime that is reasonably likely to cause physical or financial harm to another person, and complying with a direct order from a court of law.
Exactly. And mandated reporting, which is covered under Code 3.01, is really the heaviest of these responsibilities.
Definitely.
Behavior analysts, including RBTs, are mandated reporters. If you suspect a child is being abused or neglected, or if a vulnerable adult is being financially exploited, you must report it to the state immediately.
I would think of mandated reporting like a circuit breaker in a house.
Okay, I like that.
Right. When the system is running normally, electricity flows through the established channels. But the moment that breaker detects a dangerous power surge, like suspected abuse or neglect, it automatically trips to prevent the entire house from burning down.
Right.
It doesn't wait for permission to shut the power off. It just does it.
I love that analogy because the sources are incredibly explicit on one vital detail. You do not ask for permission to trip that breaker.
You don't ask your boss.
No, you do not need to consult your clinical director. You do not wait for your supervising BCBA to approve your decision. If you see the signs of abuse, your legal obligation to call the authorities is direct and immediate.
Wow. Okay, let's look at another critical safety mechanism from the sources, which is the medical rule-out. There's an intense case study, case 2.12b, about a non-vocal teenage student with cerebral palsy.
Yes, this case is a perfect illustration of how behavioral science can actually become dangerous if it ignores biology.
Oh, absolutely.
So this teenager has a history of seizures, presenting with a startle reflex and jaw tremors. But recently, he started having incidents where he forcefully locks his jaw, sometimes biting his tongue or lip, to the point where it has happened on the school bus and required an ambulance because his breathing was compromised.
And the school district is looking at this and saying, we have a behavior problem. The student is disrupting the bus. BCBA, please fix this behavior.
Right, they want a behavior plan. And if the BCBA treats this purely as a behavioral issue, they might try to implement, like, an extinction procedure.
Which would be what in this case?
Well, assuming the jaw locking is for attention and intentionally ignoring it to decrease the behavior.
Oh my gosh.
Or they might try differential reinforcement, rewarding the student when his jaw is relaxed. But applying those behavioral mechanisms to a neurological misfire is not just ineffective, it is life-threatening.
You are essentially trying to functionally assess a seizure.
Exactly. Which is why the ethical mandate requires a medical referral first. Before you even draft a behavioral hypothesis for a new sudden physical symptom, you must rule out medical or biological factors.
You have to.
If you ignore a potential medical condition, you are violating the core mandate to do no harm.
And this brings up a massive point for anyone taking the 6th edition exam. If you are sitting in that testing chair, 4 hours on the clock, staring at a convoluted paragraph about a client displaying a new severe behavior, and the question asks what the BCBA should do first.
The trap answer will always be something clinical. It'll say, conduct a functional analysis or begin collecting baseline data.
Right.
The correct answer is always the medical rule-out. Client safety in biology trump behavioral assessment every single time.
And client safety is so paramount that the BACB actually requires practitioners to maintain a high standard of lawful behavior 24 hours a day, 7 days a week. It doesn't stop when you clock out of the clinic.
No, it doesn't. The BACB handbook outlines very strict self-reporting requirements. Your personal behavior comes under intense scrutiny if it poses a potential risk to the health and safety of your clients.
Right.
For example, you are required to self-report to the BACB within a specific time frame for public health and safety tickets. A prime example is a DUI.
Which a lot of people might wonder why a DUI on a Saturday night is the board's business if you are totally sober at work on Monday.
Yeah, I hear that question a lot, but the board's logic is that a DUI implies a potential substance issue, or at the very least, a severe lapse in decision-making and impulse control.
Makes sense.
If your judgment is impaired to the point of risking lives on the road, that impairment could easily bleed into your clinical practice, where you are responsible for the safety and development of highly vulnerable individuals.
Right, you can't separate those two things easily.
Exactly. You also have to self-report unpaid child support or any physical or mental condition that suddenly impairs your ability to safely practice.
Wow.
And on a purely administrative note, you even have to self-report simple change of address or a name change.
Really? Just an address change?
Yep. The burden of keeping the board informed rests entirely on your shoulders.
That's a lot of personal responsibility.
Mm-hmm.
And that level of ownership ties directly into Code 1.03, which is accountability.
Mm-hmm.
The sources provide a scenario where a BCBA designs a behavior plan, but fails to communicate the reaction strategy to the RBT. So the RBT executes the plan poorly, a crisis occurs, and the stakeholders, maybe the parents and the school, they blame the RBT.
Yeah, and in a high-stress moment like that, human nature might tempt the BCBA to just stay quiet and let the supervisee take the fall.
It was their fault they implemented it wrong.
Right. But demonstrating accountability means the BCBA must step up immediately. They have to communicate their own oversight to all involved stakeholders and take full responsibility for the failure.
Because it's their plan.
Exactly. The ultimate responsibility for the design, communication, and implementation of that plan rests with the supervising BCBA. You protect your supervisees. You do not throw them under the bus to save face.
So we've woven a few exam tips in already, but let's synthesize this for the listener who is actively prepping for the board exam right now.
Yeah.
We have solid data on what this test demands.
Oh, we do. So the 6th edition test content outline specifies 175 scored questions, plus 10 unscored pilot questions, with a strict 4-hour time limit.
It is a marathon.
It is an absolute marathon of cognitive endurance. And Domain E, which covers all the ethical and professional issues we've been unpacking today, makes up a massive 13% of the test.
Wow, 13%?
Yeah, that is roughly 22 scored questions. You mathematically cannot pass this exam if you rely on guesswork for the legal and regulatory domain.
So when you are reading a scenario that wraps the legal and ethical and a clinical dilemma all into one paragraph, what is the filter for eliminating the distractor answers?
The golden rule is the client-first lens.
Client first.
Always. If a question asks what you should do first, the correct answer prioritizes the best interest and safety of the client above the convenience of the agency, above the demands of the insurance company, or the ego of the practitioner.
Can you give an example?
Sure. For instance, if you receive a referral for a client in a different state, the first move isn't consulting your local peers. The first move is researching the jurisdiction and regulations for the client's state to ensure you can legally protect them.
So you just filter every choice through that single question. Does this action protect the client's rights and safety above all else?
Exactly. If an answer choice suggests delaying a mandated report to ask a supervisor for advice, cross it out. If it suggests implementing a behavior plan before a medical doctor has looked at a locking jaw, cross it out. Client biology, client safety, client rights, that is your compass.
That is so helpful.
Yeah.
So what does this all mean when we step back from the regulations in the exam prep? We started today talking about how murky the legal landscape of ABA can be.
It really can be.
But understanding these requirements, Domain E12 isn't just about memorizing a textbook so you can pass a 175-question test. It is about having the integrity to protect people who often cannot protect themselves.
Absolutely. The entire architecture of the ethics code, the licensure laws, airtight service agreements, rigorous confidentiality, and stepping up as a mandated reporter, all of it exists to ensure the science of behavior is used for good.
Right.
When you follow these frameworks, you aren't just covering your own legal basis. You are building public trust, and you're elevating the entire profession.
Beautifully said. But, the landscape is never static.
No, it's not. Which brings up a fascinating thought to leave you with today. We've spent this deep dive talking about how to follow the laws currently on the books,
Right.
but behavioral science is advancing at breakneck speed. We are pushing into global telehealth, we're integrating artificial intelligence into data collection, and exploring advanced neurotechnology.
It's moving so fast.
Too fast sometimes. Imagine a near future where the science moves so fast that the legal framework simply cannot keep up.
Oh, wow.
When the law is completely silent and there is no specific code item to guide you through a new technological dilemma, how will the next generation of behavior analysts figure out how to regulate themselves?
Wow. When the law is silent, how do we regulate ourselves? That is a profound question to chew on as the field evolves. Thank you so much for taking this deep dive with us today.
It is a pleasure.
Keep questioning, keep learning, and keep holding the standard of this field as high as it can possibly go. And remember, if you want to dive even deeper, you can access study guides, tools, and ABA resources by visiting stan.storatherapyservices. That link is right there in the show notes. See you next time.